Any mention?
May I please, Your Lordship? Lordship, I beg to mention item number 18, Lordship. It's a joint request from the private respondent.
18?
Yes, Your Lordship.
I am for the state, Lordship.
Yes.
After 2 weeks, Lordship. Lordship, no objection.
Joint prayer made by the parties. This is matter for 2 weeks. Yes.
Deeply obliged, Lordship.
Much less, Lordship.
Chief, I beg to mention item number 6 and 7, Lordship. So I was out of station. I reached today, Lordship. So I have some difficulties today. It was hard at length, so I have to refresh again, Lordship. 1 week, Lordship. Next week. Let it be any date
There
next
are
week.
many matters like that where hearing is
Yes,
done
yes,
and
Lordship. Next week, Lordship. Yes.
6, 7.
Yes.
6, 7, 8, Your Lordship. A also is connected.
Okay. 6, 7, 8.
Any day next week, Lordship.
One prayer made by the parties. List after 1 week. Yes.
Apply, Your Lordship.
Obliged.
Yes.
Your Lordship, I beg to mention item 16. I pray for some time. Item 16.
16. Yes.
Yes, Your Lordship. I was instructed by my senior counsel to pray for
Who is
some
your
more time.
senior?
Ma'am O.I. Bang.
Okay. How much time you want?
2 weeks, Your Lordship.
No objection.
And prayer made on behalf of MS Oibang, Learned Counsel, appearing on behalf of the petitioner. This is matter for 2 weeks. Yes.
And obliged. Please, Lordship. Lordship, I beg to mention item number 4.
Yes.
Lordship, a similar matter is pending division bench.
Grand division.
Yes.
My lord. My lord, the issue here, my lord, similar issue is pending before the DB.
So then why do we have it here? Is there any requirement or any like separate prayer here in this matter?
Probably that has gone for appeal, ma'am.
No, but then if it is gone for appeal, then this would not remain here. This would also go. As the parties service that the connected matter pending before the division bench is here to be disposed of. This is a matter after 4 weeks.
2 weeks, Lordship. Much obliged.
May I please, Your Lordship,
Yes.
item number 17. So, report from the Office of the Legal Service Authority
Yes.
yet to be received, but it has been completed in Tura, but here it has reached or not. So, it may be come after a week.
After 1 week. You expect it to come after 1 week?
Yes, my lord.
Yes, madam.
My lord, yes, we are awaiting the report of the
Okay.
Malsa, my lord, as per the last order. So I'm not aware, my lord, what is the status of the report.
You just say on prayer made by Mr. Hajarika, Learned Counsel for the petition, list after 1 week.
Much.
Lordship, I beg to
Yes.
mention item number 9.
Yes.
I'm praying for 2 weeks of time, Lordship.
Why are you asking for 2 weeks' time?
Our senior is having some personal difficulty.
This is a problem, you know. If your senior is having problem always, then somebody else should take over the charge.
Lordship.
It's a problem. So all the matters cannot be adjourned just because of want of the presence of senior. Yes.
Otherwise, the matter has already heard, but
We do not know. See, Mr. Abraham, probably almost all the matters before this court are like that. Heard when nothing has been done. Somewhere. This one prayer made on behalf of Mr. K. Paul Leonard, Senior Counsel, appearing for the petitioner. Not objected to by Mr. Abraham, London GA, appearing for the state respondents. List after 2 weeks. Yes.
Lordship, similar prayer for item number 3 and 8.
Item number 3 and 8.
3 and 8, Lordship.
Yes, 3 is who is appearing 3 for the respondent? Yes, madam, what you will say?
Which one?
About 3?
No objection.
No objection. It's a matter for. So you want it to be
6, 7, 8 already.
just 3 also, you just write the same thing? This is 6 thing? prayer made by and say, learned counsel.
678 already adjourned, Your Lordship.
No, he is 3 and 4.
No, 8 also.
No, Lordship, 3 and 8.
3 and 8. 6, 7, 8 is already.
Already adjourned.
3 and 8.
All that.
May it please the Lordship. Lordship, I beg to mention item number 12 for the private respondents 4 and 5.
Yes.
No objection, my lord.
May come up next week
You are
itself.
appearing for?
Private respondents 4 and 5. Lordship.
So why you are mentioning? Why, if you want it next week, why not today?
Lordship, there's some difficulties with the conducting counsel.
I was already informed, my lord. No objection.
One prayer made by so and so, learned counsel is appearing for this one. List after a week. Yes.
I'll elaborate, my lord.
Item number 1.
Yes. Who is appearing here? Chair, Mr. L. Mirching Marpan. None appears for the applicant. This is the miss case, huh? None appears in the applicant. List after 1 week. None, yes, none appears for the applicant. List after 1 week. Yes.
Item number 2.
Yes.
Your Lordship, I don't know, we can dispose of this the next week because I have taken the instruction. I have also new CEO has joined because it rejected that although there is no ground for review. Let me very fairly
See,
submit.
Mr. Mahanto, you may say that the statute may require something, but then when there is a specific authorization by your department authorizing that person, so
No,
entire
only the-
settlement cannot be ported.
That can
It is only the technical aspect.
technically.
So that is all right. Technical aspect that will never bind you again and again because this officer appeared only on one authorization. He was not given a permanent authority. So for any settlement of any kind of any similar matter of this kind, that will depend upon whom you authorize, whom you do not authorize, isn't it? Yes, Mr. Gautam.
It can be done dispose of. Like,
Review as it is not maintainable. Can't be. It's a consent order, my lord. How can we review that consent?
Shall I dispose it of saying that you are
but
not,
I cannot
pressing it?
only honestly submit. I cannot concede that part. You know, dismiss that. I think that will suffice. I think. Plain and simple. Because no ground has been met out for that.
So then in such a case you have to make your argument, then you have to record your argument. Then if you want to say that.
Only the technical aspect of this authorizing the signature.
No, but then that basically can be a ground for review, just show us.
No, that cannot be. In fact, I should have gone to the tribunal
Yes.
to the same court. Material.
Just a hard question.
Only that part can be left open and nothing else.
That is, see, there is
Yes.
no requirement of it because it is understood that that officer was authorized only for one matter. Isn't it? Have you enclosed the authority letter here?
Yes, it is there.
That was it not for the specific that case?
Only that case. For
Then your review petition becomes misconceived. Then, pardon, Mr. SP Monto, Honored Senior Counsel assisted by Mr. Lindo, appearing for the petitioner. Mr. Gautam, you are appearing for?
I'm for respondent number 1.
And who is respondent number 2?
I'm for 2.
Okay, so and so for 1 and so on. Better, sit down, sit down. By this review application, the applicant has sought for a recalling of order which order we have sought for recalling? Okay, 20 recalling stock test of review of order dated 22. Just a review of order dated, not a recalling. A short review of The order dated 22/9/2025, passed in WPC number 406 of 2018. And this order was for 2 writ petitions, and passed in and WPC number 408 of 2018. This is one is 406, another is 408. The prime contention raised in this application is that the settlement agreement dated 17/9/2025, basing on which the aforementioned writ petitions were disposed of, was not entered into by an official as per the requirement of what is the law? Which law says that? What is the law which says that this officer cannot do it? What is the law? Name of the act? Which
Mediation Act 2023.
what is it? Was agreement has not been entered into by the official petitioner, official of the petitioner, in terms of the what is the act, please?
Mediation Act 2000. The Mediation Act 2023.
In terms of the provision of the Mediation Act 2023. Stop. The respondents, the learned counsel appearing for the respondents, resisted the said contention, resisted the plea raised on behalf of the applicant. Please sit down. By contending that the ground urged on behalf of the applicant cannot constitute a ground for review of the order. Stop. Yes, Judge. Yes, sir. A perusal of the material of the record reveals that the agreement dated 17/9/2025 was entered into between the parties after the review applicant was represented by an officer who was specifically authorized to negotiate the matter concerning the writ petition number so and so and so and so. Stop. Nothing has been mentioned in the order that the said officer would represent the applicant department in all subsequent proceeding of similar nature. Stop. As the settlement was attained after the review petitioner was represented by an authorized officer. This court finds there is no ground, no merit in this review application. And the same is dismissed. No cost. We may just alter the construction of sentence, but then it will remain there.
Only fear of the controversy, they may not take as a precedent for the other cases.
That is why we have said that it was specifically for this. And there is nothing to show that for subsequent.
Much
Hearing item number 5.
Yes.
Yes, Your Lordship. Your Lordship, this is that matter which we have filed miss case. 3 miss cases we have filed, Your Lordship. Registered as 161 of 26, 162 and 163 of 26, Your Lordship.
Okay, these are for your what is your prayer in the miss case?
We have filed 3 miss cases, 2 of which we are praying for substitution of the writ petitioner, Your Lordship. And then the other one is for striking of the remaining writ petitioners, Your Lordship. Lordship, miss case number 161.
Mr. Nongri, you are appealing for the respondents.
Private respondents.
So you have any objection to whatever?
There are 2 applications which I have no objections, but other one I need to take instructions.
The striking of? Or the implement?
Substitution,
Oh, substitution.
I have no objection, Your Lordship.
So there are 2 applications for substitution?
3 applications.
For substitution, 2 applications, Your Lordship.
Yes.
And then the other one is for striking
for
off.
striking off.
Yes, Lordship.
Substitution, I don't have any objection. What number is that?
Who is sought to be substituted in whose place?
The writ petitioner, Lordship.
Now this
Yes.
application has been filed
Yes, Lordship.
by the person who is seeking
To be
substitution.
substituted. Yes, Lordship.
I mean, they want to be in the place of the substituted.
Yes, Lordship. Because the writ petitioners are the villages represented by the headman. And then now the
So
headmen
what are those applications? Just to give us, what is the first application? Yes, madam, you are appearing for?
No, she is assisting me.
Okay. So why Mr. Abraham is there?
He is appearing for the state.
Only for the, I'm appearing
Just
for the
sit
state.
here now, you sit there.
But then
and
you
have
can
nothing to say.
adjust accordingly. Just, I think so that there will be no confusion for the court.
Absolutely, Your Lordship.
Because otherwise it appears that she is appearing for some other respondent. Yes. What is the application first you want us to take up? Application number?
Miss case 161.
161.
Yes. This is for substitution of the writ petitioner number 8, Your Lordship.
And what is the ground?
The ground, Your Lordship, because earlier it was represented by the headman, and then now this person is not in office anymore, and then a new person comes in the office, Your Lordship. That is just.
Okay.
Yes.
And how many existing respondents are there?
Respondents, no changes, Your Lordship, only the writ petitioners.
Only, no, just a minute. You are seeking.
Your Lordship, there are 14 writ petitioners.
14 writ
So
petitioners.
whether all have been served, whether any of them have any, you are representing all.
7 and 8.
And who, the others will be represented by whom?
District
Others
council
is
there,
district council, Your Lordship.
State is also there.
Then what about 9? Okay, not 9. Just a minute.
9.
No, not 9.
There's no 9.
Yes, there is no. You are 7 and 8.
I'm
What
7
about
and 8.
District council, who will represent district council? And 1, 2, 3 and 6. What about 4 and 5?
4 and 5 is Abraham.
Okay, so none of you have any this thing. Just note who is appearing for whom. Okay? Okay? Just say hard. London council is appearing for the parties. This is Miss Case 161. But this application. This is an application seeking substitution of the writ petitioner number 8. Namely Sri Brillition Nolan.
We are
By
only existing now, so. Wait, which one we have objection?
applicant.
So substitution, we don't, only these 2 we need to take instructions now.
On the ground that the applicant has superseded.
Not it means only 3 petitioners left.
The petitioner number 8.
Common meaning?
Like the ones that are still exist. The common ones that are the ones that are
Just say Do not say superseded. Just say applicant has replaced the petition number.
Only this much left. 3, 4, 1, 2, 3, 4, 5, 6, 7.
The office of the headman of Langpi village. From our right, Maja, West Pacific district, Meghalaya.
At extraction, yeah. Choosing.
And he is no longer in a position to represent the writ petitioner anymore. Stop. Paragraph. The prayer made in the application has not been objected by the learned counsel applying for the respondent number. Respondent, I don't know what I mean by respondent.
So confused.
As the applicant herein has replaced the as there is no dispute that this applicant here has replaced the responsibility in the office of the headman of such and such village, Langpi village. Comma. The prayer made this application is allowed. The applicant is allowed to replace the number 8 in the petition number 62 of 2017. Stop. The applicant. Stop. The do not say. Just say the cost title of the WPC number 62 of 2027.
Yeah, that is 6, 8.
62 of 2017. Maybe amended accordingly.
This one that means.
By the council representing the applicant. Stop. Dispose of misses. Dispose. Okay. Then next.
Next is the Miss case number 163 of 26.
Okay. So here who is sought to be replaced by whom?
Lordship, this is for substitution of the writ petitioner number 7. The same case here also, Your Lordship, because the.
So this will be just a minute. 162 is striking off.
Yes, Lordship.
And then 163.
163. Yes.
Okay. 163 is
Writ petitioner number 7.
writ petitioner number 7.
Yes, Lordship.
And what is the ground there?
The same ground, Your Lordship.
But then two different.
Two different.
So here also this same thing. This will be substitution of writ petitioner number 7, as he was replaced by the applicant
Will make it clear with this application.
in the office of the headman of the Nongdrang village. You can get it from petition. Okay, and rest everything will remain same.
Yes, Lordship.
Only 7 in place of 7. Same thing. You have no objection there also.
Yes, Lordship.
Okay. Yes, madam. No objection. Yes. You have to stand up and say. You see, if you shake, do this thing, court may not notice. Okay. Yes, 162. What is to be done? Okay. Heard Mr. So and so, learned counsel for the applicant. Then Mr. So and so, Mr. So and so appears for the respondent number so and so. Okay. As prayed for by Mr. Longmead, learned counsel appear. You also will take instruction, or you do not need.
No, Your Lordship, Your Lordship, only there's some confusion. 161, 62 and 63, all of them may be allowed. Because my instruction till date, Your Lordship, is that a few of the writ petitioners has acceded to us. So I'll bring that on record. Who are those writ petitioners?
No, but then if you say that, then it may happen like that the person sought to be brought in here, maybe in your side.
Maybe, Your
So
Lordship,
is it not
that I'll
you
have
have
to take
instruction. I think that is
instructions.
better. That will be, otherwise it will create a confusion. Today,
Yes,
if you give
Lordship.
no objection to their implementation
Yes.
petition, tomorrow if you come with that thing, then that will, you'll be contradicting yourself. So we'll just say, as per by Mr. Longmead, under counsel appearing for so and so. How much time? 2 weeks.
3 weeks, Lordship.
3 weeks time is granted for taking instruction. Okay, list accordingly. All right. The writ petition also will be listed along with Miss case number so and so. And then the other thing you correct the
Yes,
postal
Lord.
11.
Yes, Lord. I'll do it. Matter lodged.
Oblige.
Yes.
Item number 10.
This 62 is not disposed of. Out of 3, 2 Miss cases are disposed of. Yes.
May I please, Your Lordship?
Yes. What is this case about?
My Lord, this case pertains to, my Lord,
Who is appearing for the respondents? You are for the
for the Managing Committee.
Managing committee.
and state?
State is.
Okay.
My Lord, will recall, my Lord, in fact, my Lord, of course, this matter was heard in between, but to refresh the memory of the court, my Lord.
When it was heard?
My Lord, number of times, my Lord. So, my Lord, this is a case of the petitioner was appointed, my Lord, as assistant teacher in the
You please take seat out there.
in government aided school, my Lord.
Assistant teacher is it?
In the government aided school, my Lord. So, my Lord, initially the case of the petitioner is that
What is that school? Name of the school is?
Bhanubhakta Nepali School, Nongmen Song. My Lord, what has happened in this present case, my Lord? Way back in 1986, my Lord, the petitioner herein was appointed not in the LP section, but in the upper primary section of the same school.
She was originally appointed in upper primary.
Upper primary school, my
What
Lord.
is the date of?
Is 17 September 1986.
You can go. Just
That is Annex of
1 minute, Mr. 1 minute. Annexure?
Annex of 1, page 9 of the writ petition, my Lord. If I may read, my Lord.
Yes, please.
To so and so, the managing committee is pleased to appoint you as an assistant teacher in a consolidated salary of rupees so and so per month with effect from the date of your joining in a purely temporary basis for a period of 6 months. Your service will be extended for a further period after considering your performance by the committee from time to time. This will not constitute any claim whatsoever in future, my Lord.
That is a letter dated November 20, 2011.
9th September 1986.
Annexure 1,
1,
page 9.
page 9 of the writ petition.
This is November 20, 2011. Later, on the top, number so and so, November 20, 2011.
No, 17 September.
Is there any other writ petition?
Okay, wait, just a minute. This court is having wrong
17th
affidavit.
September.
Wait.
It's 17th September.
You're looking at wrong affidavit.
Lord, Lord, I have a small prayer. My humble apologies.
But I'm having some difficulty to tell if it is taken.
Rejected. No question. Yes, please.
My lord. So, my lord, after our initial appointment, my lord, the petitioner, my lord, served till the year 1997 in the same upper primary section.
Now, this is appointment by the managing committee.
Yes.
Doesn't show that you have been appointed in a sanction post.
No. I'm not into that, my lord. Because my appointment is temporary.
This is a query from the court. So your original appointment,
Yes.
so far is not. It doesn't specify whether it is in a sanction post, isn't it?
It is not sanctioned post, my lord. It is
Then whether it was approved by the state or not. Okay. So
My
there
lord,
is the
my lord,
first one.
if I may, my lord, if I am appointed in a sanctioned post, my lord, then in that case, my lord, a managing committee has to communicate with the state for approval. But since I am not in a sanctioned post, my lord, so no question arises in that. So, my lord, my initial appointment is in the upper primary school, upper primary level of the same school, in a unsanctioned post.
This is ME means upper primary, isn't it? Middle English.
My lord.
Middle English and upper primary is same.
My lord.
Connotes the same meaning.
So, my lord, for more than a decade, my lord, I served as assistant teacher in an unsanctioned post in the upper primary section of the school. However, my lord, on 25/5, that is 25th July 1997, my lord,
Yes. Yes.
in the lower primary school level of the same school, my lord, there are 3 sanctioned posts from the government side, my lord.
Okay.
In lower primary section of the same
In
school.
97 there arose 3.
No, my lord. Since beginning, my lord, it was there. But because I was not concerned with that because I was in the upper primary and that too in unsanctioned post, my lord.
So there are 3 vacancies
There were 3 vacancies, my lord.
in sanction post.
Sanctioned post in the lower primary, my lord. But I was in the upper primary, my lord, serving in the upper. Now, it so happened, my lord, after I served for a decade in the upper primaries level, my lord,
Yes.
one of the assistant teacher of the lower primary LP, that is the sanction post, she was serving in sanction post. Her name was Basanti Joshi, my lord. She had been absent for more than years. Subsequently, the education of the children in the LP section was, my lord, suffering. For a temporary measure, my lord, I being the senior most teacher, my lord, I was roped in, my lord, brought down.
And what was the qualification criteria?
10th. At that material point of time, my lord, it was matriculate for LP section. It was only in 2011, my lord.
Then what about at that point? What is the requirement for upper primary school teacher?
Upper primary teacher also, my lord, 10, 12, there was no, my lord, standard followed by the
qualification or the issue here in this case?
No, my lord. Because at that
just tell us what is the dispute in this thing before
the dispute is that, my lord, I joined the service in a prime age of about 22 years, my lord, having served for about 40 years, my lord. And that too, I have my appointment in the LP section in a sanctioned post, my lord, by the managing committee, and managing committee is the authority for appointment, my lord. Now, what happened, my lord, behind my back, my lord, I am not to be blamed, my lord. The managing committee should have communicated with the state government.
No. What is your grievance here? Just do not come to the merits later. Just tell us, just for proper application of mind, the court wants to know what kind of grievance you have here.
My grievance is that, my lord, after serving more than 40 years, my lord, in a sanctioned post, suddenly, my lord,
40 years. So you joined that sanction post in 1997?
My calculation is right from my appointment as the upper primary teacher, my lord. But here in this case, about 27 years I have.
Now your service is terminated. So you are
not terminated, my lord. What has happened, my lord? After my appointment as assistant teacher in the lower primary, my LP, after serving for about more than 2 decades, my lord, suddenly the state government, my lord, wakes from slumber and passes a order directing the managing committee, because my post should be advertised.
Okay.
Now, what had happened, my
The
lord?
thing is that when you shifted from upper primary
To the lower primary.
to lower primary, you continued there for a considerable period of time.
Considerable, more than 20
Your
years.
initial shifting was a kind of stopgap arrangement.
My lord, as of
And then
officiating
you
teacher.
continued for how many years?
My lord, from 97 till 2017. 2017.
So 2 decades.
2 decades, my lord.
And now you are reverted back to your original.
No. The school is silent, the managing committee is silent on that, and even the state government is silent on that. And I have been going to the school, my presence, my attendance is not recorded, my lord. That is the situation here, my lord.
From when? From 2017 you are out of service.
Out of service, that is as per the record, because my attendance is not there, because my salary is not.
Okay.
My lord,
So that is what makes you out of service. Just because you are going inside that and standing somewhere outside the school.
No, my
Out
lord.
of service means whether you are performing your duty or not.
No, my lord. Because there is no speaking order from the managing committee or from the state government that my service has
Are you
been.
performing duty?
I'm not performing because I'm not being given the chance.
So it means you are out of service for such a certain. You may term it that this is illegal.
Exactly.
You may say.
Exactly.
So that is a difference.
But it is not termination, my lord.
We are saying you are out of service.
Exactly.
Out of service can be for many things.
Many reasons.
You are not allowed. You are not allowed to enter. That also
No.
becomes-
I'm allowed to enter, man.
So that is what.
I'm allowed to enter just
So you are out of service from 2017.
2000.
So it means you are not been able to perform your duty from 2017. It is correct.
From 2019, man.
2019.
That is 22 years.
Okay. And now thereafter 7 years have left. You have remained like that.
Yes,
Without
ma'am.
salary, nothing.
No salary. No.
And what is your age now?
I'm already in the age of superannuation, my lord.
Then
50.
what kind of relief you expect here?
Of course, my lord, even after serving for so long, my lord, even if I retire, my lord, I'm entitled to my salary and increments, my lord, gratuity.
Now, what was the rule applicable at that point?
Yes, I'll come to that, my lord. In fact, I have prepared an exhaustive, my lord, written argument, my reply, everything, the case laws and the state acts that are attracted in that.
What is your prayer in the writ petition?
My lord, it is at page 6. If I may read, my lord.
Regularize.
To regularize the service of the petitioner with
But
effect.
here you say from 1/6/1997.
Yes, 1/6/1997, my lord.
Areas of
Because
increment?
my lord,
And the salary? from
1997 was
1/6/2019. Salary you want.
yes,
That is what your prayer is.
yes.
And when did you attain the age of superannuation?
My lord, for that, I have enclosed my birth certificate.
No, according to your calculation, when?
My date of birth is of 1966, my lord. So my length of service till the age of 58, my lord. So in that situation, my lord, it is.
See it for government teacher. For aided teacher, probably it is more.
My lord.
Just see, verify.
No, my
it.
lord.
You must know it.
My
because
lord.
You are,
No, my lord.
My lord, the age which is shown in the affidavit, my lord, is 53 years.
That is.
So going by that, my lord, she has already reached superannuation. She'll be 61
that is
years.
what Mr. Gurung is not disputing that. No, we are just trying to know what is the date of superannuation. We are just trying.
Date of superannuation will be 60 years.
That is what. You said 60. You are 64. Born
My
in
lord,
64.
I'm 62 right now.
No. You are born in 64.
1966, my lord.
1966.
My lord. So
1966. That means you are 60 only.
Not my apologies. For the government school, it is 58.
See, government school means only of the status of a government school. Aided school is 60. And he is teacher of aided school.
Yes, for aided.
You see, it may not be very vital, but then we must know what is the position. So, if you are born, which month? 1966, which month? What is the date of your birth? What is the date of
It is 1/3/1966.
1/3/1966?
Yes.
Means February you have February this year. You have completed 60 years.
My lord.
Okay.
Yes.
Okay. No, just say. So the factual things. Is that okay? 86 your appointment. Upper primary. 97 you moved to lower primary.
My lord.
And you started functioning in the league vacancy caused by one person.
Initially, as officiating, my lord.
You are Sangeeta Pun,
My lord.
substituted assistant teacher. This is
Exactly.
annexure 2, isn't it?
Yes.
Now, this substituted assistant teacher arrangement was made by the Secretary Managing Committee. Okay.
Now, my lord, kindly come to my lord, page 12, annexure 4 of my writ petition, my lord. That is the.
Now, substitute teacher, it doesn't say about under pay and all, isn't it?
Doesn't say, my lord. Doesn't say anything.
Now, if a person is engaged, normally that is a general question of law. In such a situation, if a person is engaged as a substitute teacher, whether that teacher is entitled to all the salary of the person in place of the person.
No, my lord. It cannot be.
So,
It cannot.
your service in that school
My lord.
was in what capacity, which way we determine it? If
Lord,
it is not shown.
Exactly, my lord. Because, my lord, the scenario changes drastically thereafter, my lord.
Yes. Then, page 12.
Page
What is,
12.
what is page 11?
This is subject to approval of the deputy.
See, what you have shown us at page 10, it is only a resolution. It's not an order. Page 10 is only a resolution. It's an abstract of resolution.
Page 10, my lord.
Yes.
No, my lord, I had laid your lordship to page 9 initially.
Yes, the page 10, the second part,
My lord.
the decision to make you a substitute teacher,
My lord.
and if it is page 10, is made on the basis of page 10.
Well.
Page 10 is nothing but an extract of resolution. of the
Exactly, my
managing
lord. Exactly. Exactly.
Okay. Now please move ahead.
My lord, we'll come to page 12, annexure 4. That is the letter dated, office order dated 14/4/1998. Now here, my lord, this is the stage, my lord, 14/4/1988,
This annexure
annexure 4.
3 is not relevant.
My lord, 3 is, my lord, basically, no, my lord, I'll come to page 12, my lord. If I may read, my lord. My lord, by the order dated 14 April 1998, my lord, I was confirmed in the...
Come to page 11.
Yes.
Now, if you see this order, your appointment is not in leave vacancy.
Sorry, my lord.
Page 11.
Yes.
Please read it. What does it say?
Subject to the approval of the Deputy Inspector of School, Shillong, Srimati Sangeeta Pun, HSLC, is hereby appointed as assistant teacher in the scale of pay of rupees so and so, plus other allowances as admissible vice so and so, my lord.
Yes.
The appointment shall take effect from 1/6/1997 and is purely temporary, may be terminated at any time without notice and without assigning any reason.
So it means, from here we can infer that you have joined in a post held by Basanti Joseph.
Yes, yes. That is my submission right from beginning, man.
But then your service was not
Confirmed. Not confirmed, yes.
Wait. We have not finished. It was not up to the period of return of Srimati Basati Jasi. It is never been stipulated
Yes.
that you will vacate the post once Basati Jasi comes back.
No, it is
and
not.
resume.
It is not there. It is not.
Isn't it?
Yes.
So it is a vacancy created by Bashanti Joshi's
Yes.
ouster from service, whether it's a retirement or by whatever, do not know.
Yes.
But then doesn't show that leave vacancy.
Exactly.
So this resolution which you have seen in the previous page is unrelatable to this order.
Yes.
Okay. Now this is 1st June you are appointed
1st June 1997, my
by
lord.
the Secretary Managing Committee.
Yes, my lord.
Now that prepared approval of the
My lord.
government.
My lord.
Now come to
Now,
14th.
kindly come to page 12,
Yes.
Annex 4. Now, this is the, by this letter, my service as assistant teacher has been confirmed, my lord, by the managing committee. If I may read, my lord. In partial modification of the office order number so and so, dated 1st June 1997, the pay of Srimati Sangeeta Poon, assistant teacher, is refixed at the stage of rupees so and so. So I am getting all scale, my lord, with effect from 1st June 1997, with date of next increment as on 1/6/1998.
It doesn't say about approval, it only speaks about refixation of salary.
My lord, if I may, my lord. Now, what is approval, my lord?
Yes.
The managing committee is the, my lord, authority for appointment, my lord, for added school.
Okay.
Yes. So, my lord, it is the managing committee who appoints. Now, thereafter, it is the managing committee to communicate with the state authority for my
Yes.
regularization of my service, my lord. Okay. So, my point is that, my lord, if for decades the managing committee had been, my lord,
Why you are coming to decade? Just confined to 1998 now. Do not travel that further at this stage.
my lord, the query came from my lord.
That may ultimate add to your submissions over as merit of your case is concerned.
Exactly.
We are just examining the stage till 1998 when this letter was issued.
Exactly.
Okay. Now this letter issued doesn't say that the recommendation of the managing committee by so and so dated is hereby approved. It only say that the letter of the managing committee dated such and such.
Hence, my lord,
whereof was shown something different is refixed.
with all due respect, my lord, hence the query, my lord. So, my lord's query is that my salary has been fixed with all increments and all, my lord, but there is no approval.
But then it was for how long? That is the question.
My lord, first question falling from my lordship is, it was not approved. So, I had been...
we have not said that approved. We should say it doesn't show it has been approved.
Exactly.
Do not misread what the court says. Court never said it has not been approved. You may show it is approved in your way. The court's query is that the letter doesn't say that the resolution of the managing committee has been approved. If you see the previous page, the language of the letter of the school managing committee
Absolutely
is
correct.
subject to the approval of
Absolutely correct.
the
Absolutely.
appointment of such and such.
Absolutely correct.
Okay.
Absolutely.
Now this letter doesn't say that the resolution of the managing committee or the letter of the managing committee was approved. It
My
only says that scale of pay which is shown in that letter
Correct.
is been refixed.
Absolutely. Correct, my lord. My lord is correct. Yeah.
So there is nothing
Yes.
saying.
Yes, ma'am.
Okay. You may say it implies. No problem with it. But then there is nothing shown. So it is approved. Yes.
As the, my lord,
Now,
factual...
are you telling me it is an approval?
No, my lord. As it will unfold further, my lord, then, my lord, the confirmation takes place. The resolution of the managing committee, my lord.
So till 98 it is only modification of pay scale.
My lord, here again, my lord, it implies, my lord, subject to my lordship's... Once I have been, my lord, approved of the scale pay that was being received by Basanti Joshi, with all the increments, my lord, I am entitled, my lord.
Okay.
Lordship will come to
Yes.
Annex 5, page 13, my lord. This is the communication, my lord, made by the managing committee for confirmation of my post, my lord. If I may read, my lord. To the Sub-Divisional School Education Officer, Shillong, appointment of Srimati Sangeeta Pun as Assistant Teacher of LP Section. On the subject mentioned above, I have the honor to submit herewith a proposal for appointment of Srimati Sangeeta Pun as Assistant Teacher of LP Section in Bhanuvakta Nepali LP School, Nongmensong. It may be pertinent to mention that Srimati Sangeeta Pun, an assistant teacher of this school under MC, who was working as assistant teacher with effect from 17/9/1986, was allowed to officiate as assistant teacher LP section, vice Srimati Basanti Joshi LP teacher with effect from 1/6/1997. It may also be mentioned that Srimati Sangeeta Pun, assistant teacher LP section, is continuously working as assistant teacher LP section since then without any break. Necessary extract of the resolution adopted by the school managing committee dated 2nd October 2016 is enclosed for kind perusal. In view of above, you are requested to kindly issue the necessary appointment orders in respect of Srimati Sangeeta Pun, assistant teacher LP section.
So you had a meeting on a holiday.
My lord, is there any, my lord, restrictions on that, my lord? Since it is a private school, my lord.
You are basically replying or responding to the query of the court by another query.
My lord.
The query of the court is that you had a meeting on a holiday.
I don't know, my lord. I have to go.
So
to the
2nd
calendar.
October is not a holiday. It is a national holiday otherwise. We have few national holidays in a year. 26 January, 15th August, 2nd October.
My lord, it is a common practice of private schools. They
See,
sit.
Mr. Gurum, every query of the court does not have a negative impact against you.
No.
So kindly respond to the question that way. It's a choice is yours. Whatever way you want to do, you will do.
Yes, my lord.
Yes.
Now, Annexure 5, page 13,
Yes.
is another.
And except you have taken.
I have
out
read
the-
that. I have read that. Now, my lord will come to Annexure 6, page 14, my lord.
Yes.
This is letter dated 5th November 2018.
Have you enclosed this resolution of the managing committee dated 2/10? Is it available anywhere?
It will be available, my lord.
It is there in your petition.
It is not in the petition, but
No, we do. Is it a part of the record?
No, no, no.
We do not want to see if it is anywhere else.
my lord.
It is not a part of record.
No, it is not.
Yes.
To Sub-Divisional School Education Officer, Shillong. Subject, ex post approval of appointment to Srimati Sangeeta Pun, assistant teacher of so-and-so school, so-and-so. Sir, with reference to the subject cited above and reference to the subject mentioned above, the managing committee of the school requests your authority concerned to kindly grant ex facto approval to Srimati Sangeeta Pun, assistant teacher of Bhanuvakta Nepali so-and-so, appointed by the managing committee of the school since 17 September 1986, and she continued to be in service till date, my lord.
Yes.
Another communication, my lord,
Yes.
from the managing committee, Annexure 7, dated 17th May 2018. If I may read, my lord.
Yes.
To Sub-Divisional School Education Officer, Madam, I have the honor to invite a reference to your letter number so-and-so dated so-and-so March 2018 on the above subject, and to forward herewith a copy of resolution of the emergent meeting of the School Managing Committee convened on 13 May 2018 for favor of your information and necessary action, which is self-explanatory.
Do your petition has a copy of that 15 March letter of 15 March 2018?
My lord, in the provide this, if I may, my lord. Orders there. Last order, speaking order. So, my lord, the last hearing took place on this case on 21st September 2023, my lord.
Last hearing 2023.
My lord.
Okay, and now you are continuing that hearing now.
Exactly, my lord. That's what initially I had pointed out, though it was before the other bench, my lord. So, my lord, what had happened?
In 2023, you have argued before other bench, and now you are continuing it here.
Exactly, my lord. Reshuffling took place, my lord. Yes.
So that is all right. But then you cannot say it's a.
So, my lord,
it's a fresh
my lord's-
hearing for this court, isn't it?
My lord's query about that order, my lord.
That 15 March.
Yes. So, my lord, during the course of hearing on 21st September 2023, the same question arose, my lord, whether that letter is there, against which this reply was being filed. So, this was brought on record by way of additional affidavit, my lord, which was served to the other side also, my lord.
And what the letter says?
It says, my lord,
This is in your additional affidavit.
my lord.
Yes, additional affidavit dated 10th February 2020, isn't it? Yes. Court got it. Court got it.
In fact, my lord, the order is enclosed even with the.
Now this letter says that you are underqualified.
Which letter, my lord?
This letter of 15 March 2018.
My lord.
Now the ground for non-consideration of your request was that you are underqualified and also overage
Yes, my lord.
for process of appointment.
My lord.
So is this the letter which is impugned in the writ petition? No.
Yes, my lord. The order for advertising the post, my lord.
Now this order has been stayed by this court. No.
No, my lord. My miscase is yet to be disposed.
No, so that means till now, as of now, there are no stay exists.
No stay, my lord.
Now what happened to the advertisement and all? Was it
Nothing.
issued-
Nothing has taken place, my lord.
Who is
Till
there
date.
in the managing committee?
He is there.
Yes. What is the position so far as this vacancy is concerned, or the post held by the petitioner is concerned?
No, initially what happened, Your Honor?
What is
Lordship.
the position of the vacancy where the petitioner was working all along? That is what we want to know first, before you come to other things.
There are only two vacancy.
Okay.
Two
And
vacancy,
the
but the learned petitioner has said that there was a three vacancy. There is only two vacancy.
Okay, so out of two,
Yes.
now what happened to the position held by the petitioner?
At
Because
present,
petitioner was conferred a regular scale of pay.
yes.
So
Vice-
we presume that the petitioner was holding a sanction post.
The language itself, my lord, Vice Basanti Joshi.
No, he was not holding the sanction post. He
My lord,
was
this
on-
may be
only-
recorded, my lord.
Only on the leave vacancy he was appointed.
No, that is okay, but then leave vacancy also was on a sanction post, isn't it? Is it in a sanction post, isn't it? Even so what we want to know, okay, forget about the dispute of 3 posts, 2 posts for the time being. If it is 2 posts, your submission cannot alter the thing, neither Mr. Gurung's submission nor yours. Because it will be a matter of record, isn't it? Now, out of 2 positions, the fact remains that Mr. Gurung was in serving somewhere till 2017.
Yes.
And you paid salary till 2019, isn't it? Now we would like to know what happened to that vacancy at this stage.
My instruction is as of now that when the vacancy actually since from 2019 he was stopped from 2019 till June and July, only that is the last pay. Then after that, he was no more working.
Okay, so then who is working there in that post now?
Because in that post, some other teachers is working.
Who is there? Your managing committee, some other teacher cannot be answered. You must
That,
tell us.
That specific instruction,
See,
that
Mr.
teacher's name.
2026, what is specific instruction needed, these things? This is not the way you handle a case.
No, the instruction which I got is this one, my lord. There was only two vacant posts.
We want to know whether these 2 vacant posts are occupied or not, and if those posts are occupied, who are occupying those posts?
My limited instruction is that 2 vacant posts is already occupied, but only the specific teacher, name of the teacher, I need to
If you
get
say
the.
occupied,
Yes.
your mere submission will not do. You have to support it by showing some appointment order.
Yes,
So
Lordship.
those were issued. Where are those?
That I need to get.
When
that, only that.
When did you file your affidavit of opposition in this case? On which day?
We have filed my affidavit of opposition. 22 on 9th.
9/3/2022. 9/3/2022.
Yes.
Now, what was the position till 9/3/2022? Whether any was holding that post?
Yes, other teacher already been occupied. That only the particular teacher I need to.
No, but then you see, file the affidavit. Come, let us see your affidavit. Page 20. Let us see what you have stated. So far as the
He is
vacancy.
supporting my case, my lord.
Is it?
And now he is speaking in contradiction, but he should be held for perjury, my lord, in the managing committee, my lord. Whatever they have filed, my lord, is supporting my case and taking a U-turn, making this kind of submission, my lord.
No, I have not.
The
I have
managing
not
committee
supported.
has to be held for
I have
perjury,
only
my lord.
stated that.
See, wait, just a minute. Let him finish, then you speak. Do not, both of us do not speak. Even court also doesn't have very good temperament. That is the problem. Okay. So, raising voice may not, add to your case.
No, my lord.
Just hold on. Just hold on. If you say one thing in your affidavit and if you make some other submission, then that is not a very good sign, isn't it?
No. Let me.
If you say
Lordship.
that this position, your managing committee doesn't hold this position anymore, then there should be a prayer by you to withdraw this affidavit and file a fresh one. You have not done so. Let us see what you have stated in your affidavit of position.
He has simply brought on record, my lord, my service record, my lord, and nothing more.
You say the grievance of the petitioner is directed at the state government.
Yes. Only that.
That means you have no problem.
Yes.
You have no problem with the petitioner, it means.
Yes, I'm only saying that I neither support him, but I'm only saying that it is directed against the state government.
You are not saying that. You said something else just now. So do not change yourself. That is
No.
standing
Regarding
every
that,
now and then will not help you.
no, only
Now tell us what happened to these 2 positions.
that's why I'm trying to answer
Please
you.
state what is your instruction so far as these 2 positions are concerned.
Well, our instruction is that the petitioner's service never received approval of the government.
That is so far as the legalities of claim is concerned. But the fact remains, rightly or wrongly, you continued to disperse her salary till 2019. 2019.
So, my lord,
So, if you say that a person was not validly appointed in a position, how could you continue paying salary for such a long time, knowing that it is illegal?
my lord, the salary was going as per the sanctioned post. My lord. What government does normally is that
So
it gives the
government,
money to the managing committee.
see, Mr. Bhattacharya, your submission sometimes, you do not know on what basis you make it. Are you trying to say that salary, just because there is sanction post, salary will keep on going, without there being any teacher? Is it possible?
No, my lord.
See, the state doesn't ask for utilization certificate. Is it not required for managing committee to give it to the state? What kind of submission you are making?
My lord will kindly keep in mind, the petitioner was a substitute teacher. So, my lord, the sanctioned salary was going to that other teacher, my lord.
Your substituted salary, this other teacher.
lord, these actions.
Just a minute. If you say that, we'll go by this thing. You see, you cannot escape. Till what time the other teacher? Where is she now? And how long a person can remain on leave vacancy without salary? Just tell us. It is not matter of 1-2 days or 1-2 years. It is 2 decades. You see, you cannot justify a wrong submission when, see, totally untenable submission by making untenable submission before this court. If you say so, we'll record it, but then we will have to
Any
justify.
appointment has to be through proper channel,
22
my lord.
decades you are paying salary in the name of some other teacher.
But salary is being paid by the managing committee. My lord will kindly
Your
appreciate.
disbursement?
That is true.
Disbursement in whose name?
That is true. Disbursement is going.
No, what is true? That is true means what is true? Your disbursement in whose name?
No, that I'll have to find out.
Okay, so
But my lord will kindly see if I take.
This is a 2019 case.
My lord will
We
kindly
have taken
see.
up it for in 2026.
My lord will kindly see when the letter was sent to the government for regularization of the service of the petition.
Just tell us
That was in
after
2016.
you forwarded that letter of that March 2017,
2016, 18.
asking the managing
2018.
committee to advertise the post.
Yes.
What happened thereafter? Which way you implemented your instruction? Just tell us.
Subsequent development, of course, I have to take instruction.
It is not subsequent development.
My lord, this direction
See,
was issued to the.
2017 and now 2026.
My lord, the direction was issued to the managing
When did you file
committee.
your affidavit?
My lord, we filed our affidavit.
Let us see what you say so far as this situation is concerned in your affidavit.
My lord, our affidavit was filed sometime in the year 2020. My lord.
2020. So that means 3 years after issuance of that letter.
My lord, para 4, para 6 we have stated, my lord, that with regard to the averments made in para 2 of the writ petition, the answering deponent states that the petitioner was appointed by the school managing committee on a temporary basis, and as per findings, there is no record of the said appointment in the office of the answering respondent, nor was approval accorded to the said appointment.
So then what basis you have paid, went on paying salary, disbursing salary to that post? Are you denying that the petitioner was not paid salary till 2019?
This is exactly why the salary was stopped, my lord.
In 2019?
She was removed from the
It was
salary.
after 2 decades. Are you just merely arguing for the sake of arguing the case? That court is asking some question, you have to respond. Or you want to make some submission which would have some basis.
My lord, the managing committee will be able to give the correct answer, my lord, as far as the disbursement of the salary is concerned.
It means you just close your eyes and just keep on disbursing money to the managing committee. Is
No,
it
my lord,
that- is it that-
initially the money is disbursed when there are appointments of the sanctioned teachers, my lord.
Yes.
So when the information is given to the authorities, my lord, that these are the sanctioned teachers in our school, so kindly
Now,
give us grant.
Are you denying the fact that you went on disbursing salary to the petitioner? Are you denying that fact now?
My lord, obviously petitioner received the benefit.
Okay, so just tell us, clarify us on what basis you went on paying that amount. Is it because of mere asking of the managing committee? Or is it because that you were aware of the fact that the petitioner was holding the post?
Correctly
you will file
speaking,
an
my lord, I
affidavit.
would say the
Mr. Bhattacharjee will ask you to file one specific affidavit that whether your department was in knowledge of the fact that the petitioner was service
In
the
our
post
respectful
2019 or
submission-
not.
our
And then
respectful-
after you file this affidavit, we will decide on that basis.
our respectful submission was that the state was
we
not
do not
aware,
know.
my lord.
See, we have many education department cases. We are not seeing this kind of anomalies. Now, it seems like that your assistants, particular, also will compel the court to pass some kind of order, which that court basically wanted to avoid those unpleasant situations. Now there is no other option because this kind of argument.
I am relying on what the affidavit is saying.
No. We are asking you a question. You do not neither say here nor say there. You just take a stand that all along you have said disperse of salary in the name of the knowing that petitioner was holding service or not, or you just say that we just kept on giving to the managing committee and managing committee wanted to pay to whomever they like.
I'll
Is
file an
it
affidavit.
the situation? Now, you are standing as a government advocate, you are supposed to know about those kind of procedures, isn't it? How a salary is dispersed, whether any utility certificate is needed or not.
Yes, they have to give, my lord.
Okay, so
I have myself done a case.
That is why specifically court is asking.
Utilization certificate is required, my lord. The school has to, every
So
interval the school
tell
has to
us-
submit.
Then tell us on what made you disperse the salary for 2 decades in the name of the petitioner. Or you have dispersed the salary without there being any utility certificate.
No, there has to be utilization
So
certificate.
what is
my
this?
lord.
Give us details. And tell,
Yes,
you are
madam.
no, you are not in a position. You are not in a position to say either this way or that way.
I'll file an affidavit.
No, your affidavit is already there. Your affidavit you have filed post that letter. But then your affidavit doesn't say so. What happened to these 2 vacancies now? Just tell us. If there are 2 school has 2 sanction posts, just tell us what is the situation now? What is the position now?
My lord, kindly, if I am allowed to refer to para 9, my lord.
No, what para 9 says about these 2 vacancies?
No, there is never any question raised about 2 vacancies, my lord. Here the case was only about the
Anyway,
petitioner asking her
then
post
just
to be
tell
regularized.
us how many sanction posts are there in the school and how many are occupied and how many.
My lord, LP school is always 2 vacancies, my lord.
We are concerned about now the position which Mr. Gurung is claiming.
She was
So there
teaching
are
in the
2
LP
positions.
school, my lord.
So
In LP
you
school
say
there
that the LP school there has
2
two
vacancies,
positions.
my lord.
Now, what is the status of those 2 vacancies, 2 positions? You just come and appear in the course without doing any homework.
My lord, here
Without
the
even trying to analyze what question may come up. Mr. Gurung is seeking basically regularization in a sanction post. Is it not? These are relevant questions.
this will straight away be a backdoor entry, my lord. Whether the petitioner will
Do
have
not
the right-
divert the issue that just confined to the question of the court. Is.
Yes,
Whether it is backdoor entry or not, this court will say.
yes.
And how you allow? If you say backdoor entry, why you have continued it for 20 years? Why you have continued it for 20 years?
It is the
so
managing
20
committee,
years some backdoor appointee is a valid appointee to you, and after 20 years not.
It's not a. My lord, kindly appreciate there is not a single approval order. Yes, what my lord is stating, I would have agreed, my lord.
You see, like you.
Had there been a approval order, my lord, I would have not.
Take citizens' right in such a way that you use it whatever way you like it. We want him, you like him, you detain him for 20 years, and the 25 years you do not like him, you just throw him out.
No, my lord. My lord will kindly see if there is any vacancy. All the citizens have the right to participate in
Yes, then what happened to these 20 years? Just tell us. What happened to that provision of law for these 20 years when petitioner was serving? Where's that law? Tell us.
Yes, I understand, my lord.
You do not understand anything, otherwise you would not have not made this kind of submission. You are neither trying to justify, nor trying to oppose it properly, rather creating a puzzling situation here. Petitioner may not have any case, but then what about your action? After 20 years you pay salary to one person and then you say no, that person has no right. In 2017 you issue a letter asking the managing committee to issue advertisement. Today you are not in a position to say whether this advertisement was issued or not. What happened to this vacancy? What kind of preparation you have before you stand up before the court? Tell us.
My lord will allow me to file an affidavit, additional affidavit.
We are
I'll
not
file it.
regarding, you see, we will not allow you to filing affidavit and all. Whatever instruction you want to have, we have it by next week. We'll have this matter tomorrow. I will just say that it appears that you know nothing. This is heard Mr. R. Gurung, Learned Counsel appearing for the parties. Neither, and also Mr. So-and-so for the state respondent and Mr. So-and-so. It appears that the Learned Counsel for the respondents are not at all acquainted with the facts of the case and are not in a position to respond to the queries, relevant queries made by the court with regard to the post for which the petitioner has laid her claim in this petition. As this court would require the able assistance of the landed counsel representing the respondents. The matter stands adjourned to 1 week. Or make it 2 weeks. We'll just make it adjourned to 2 weeks for enabling them, enabling the landed counsel for the respondents to have necessary information, necessary vital information with regard to the merits of the case. List accordingly.
Deeply
It's
obliged.
very, see, this time is coming now. This court was on the other side for almost 3 decades. We understand lawyers' things, but then we are not. See, the negligence of lawyer is something totally unpardonable. We do not know. We can understand that such kind of order may not be very good so far as the counsel representing the party is concerned, but then situation is else. You just stand up and reply just to evade the question of the court. Give your able assistance. Winning and losing is a part of the case. But they do not try to escape the thing, rather. That is not something this court doesn't appreciate.
Deeply obliged.
11.
Yes. I'm not here, I'll pray for time.
What is this, Mr. Gautam?
Well, this is a criminal petition. Well, here FIR has been filed because I have not been able to pay excise duty.
Okay.
Well, then
That CR case or GR case?
Yes.
I think, yes, my lord. But I think as per the Act, I do not see the filing of a CR case. But there are some certain technical,
Go through police then.
certain technical aspects are there, my lord, which I will discuss.
Now, sir, supposing
My lords.
if the demand of the state is not being complied with, it invites criminal action.
Well, there are provisions of law which says that, my lord, if the levy has not been paid, then criminal action can also be taken.
But then-
At the same time, civil action can also be
No, but
initiated.
then if there is a statutory provision for initiating criminal action,
My lords.
will it not be by the normal by a CR case?
Well, I could not find any such thing, my lord. Normally it should be. Generally in other statutes, my lord, a CR case is filed. My lord. Here the prosecution is initiated by the DC, my lord, DC excise, and thereafter, my lord, an FIR is registered.
So DC excise is authorized to initiate proceedings.
Thereafter, my lord, a proper FIR is filed and then initiate.
And the proceedings culminates in filing FIR.
There should be a charge sheet, my lord, but in this case, the investigation has been stayed because, my lord, prima facie, there has been a lot of irregularities.
No, but then say normally the proceeding initiated by the deputy commissioner
My lords.
culminates in filing criminal appeal. Criminal FIR.
FIR and thereafter, my lord,
And
charge
thereafter
sheet.
the investigation,
My lords.
outcome of the investigation determines the case.
Well, it's. I've never come across any such case, my lord, where a person has been charge sheeted. Very unusual, also, my lord. Very unusual. And in fact, here, cognizance has been taken after 5 years. Well, after 5 years, 2015, well, the FIR itself reveals. So that is another aspect of my argument as well. Because the maximum punishment in all these offences will be maximum of 2 years. So 468 will come into play. Well, the limitation for taking cognizance of a particular offence. That is also one of aspect of my argument.
That is okay. That is so far as merit is concerned. But then you are sure that there is no provision of.
I could not find anything. Well, I did my research. I also look into it. Not come across any such cases also.
What do you say so far as
Yes, my lord, only it is always through GR case, my lord, police complaint.
GR case? So is normal citizen also is the right. I have the right. You have the right. He has the right. But then if it is for violation of some statutory requirement,
Generally, it is a CR case. We have a Drugs and Cosmetics Acts and the other acts also. They always file a CR case before the
so
magistrate.
it will come. This will basically constitute an offence under IPC.
IPC along with some, my lord, under the Excise Act as well. I've been booked on the IPC also and also the Excise Act.
And you will have to.
It's quite an interesting case.
That is the problem again. Let's say the limited capacity which the court has.
Well, it's very interesting.
See, this court basically, you see, everywhere it is. The court proceeding is heavily dependent on the performance of the court.
Absolutely.
Now you come, you please raise some law and all. that becomes your duty basically. To
My lords.
So that is what.
Yes, ma'am.
So you raise certain things and subsequently become mum. You do not do anything to assist the court in doing this.
I have just two basic grounds over here, my lord. I'll place that.
So you are not ready. Ready.
No,
My lord, I sought for time.
Seeking
I have
some
paid for
instruction.
2 weeks time.
Wait, what for? Why you want 2 weeks time?
My lord, I require some time.
Was it hard any time?
No.
Not really, my lord. It was heard at one point of time, my lord, but not. Mr. Sen was appearing for the state earlier.
Mr. Shen was representing the state.
Earlier,
Is this a matter where you have asked for time to settle the?
there was some scope, my lord, to settle, but then it did not work out.
Settlement can only be by payment of the.
Payment, my lord.
What about his prayer?
I'm sorry, my lord.
What about his prayer now?
Well, I'm okay, my lord. This
No
is
problem.
I have no problem.
Prayer
No,
may
no
be
object.
Happy birthday, Leonard G. Appearing for the state respondents. Not objected by Mr. Gautam, Leonard counsel for the petition. This is matter after.
After 2 weeks, my lord.
Obligation.
Obliged.
30.
Yes, Mr. Pasa.
Lordship, this revision I'm challenging order dated 19/8/2025.
Complicated matter.
It's not that complicated, Your Lordship. Only fact is I have instituted a
It's
suit.
simple to you or it will be
It's quite
simple to court also.
It's contrary to law, the order which has been passed.
What order was passed?
I had filed a missed case before institution of a suit to sue as an indigent person. So basically to exempt me from paying any stamp duty at that time being, to allow me to sue as an indigent person. Now the court has directed, as per the provisions of Order 33, to conduct an inquiry. Now I'm not aggrieved by that part of conducting inquiry, but the court has stated that inquiry is to be conducted by a advocate, to which I have to pay an amount of 15,000. His travelling expenses.
Then what is the purpose of
Does it
finding
defeat the
indigent?
entire purpose of Order 33 itself? So I'm only aggrieved by that portion of the orders.
What is the law with the court doesn't know anything. You see, where is the proceeding by state is a party here.
No, state is not necessary party.
Okay, which it was pending before which court?
Before the Judge District Council Court.
So then district council will be required then.
Now, Your
If
Lordship,
any
as
expenditure
per
is to be-
the
money
provision.
spending will be on district council, not on the state.
Yes. So there's an option also that inquiry to be conducted by the ministerial staffs, which means including the Sheriff's bailiff and all, and expenses is to be borne by the court itself, as per the provisions of Order
Whether
33.
court has any fund for that.
Exactly.
We cannot ask the judicial officer to spend money from their pocket, isn't it?
So if you, Lordship, can come to Order 33, Rule 1A of the CPC.
That is all right. We will come to the provision, but then before that we must know whether district council has any fund for that.
Any fund.
Because otherwise this order passed by this court may create a burden on the judicial officer.
Yes. Or even
You may come out with law. We may say that yes, court should manage the expenditure.
Yes.
But then it may give an implication that if there is no fund for that, the judicial officer has to pay from their pocket. Will be possible.
It's not possible. That's
Who is standing counsel of district council now?
Oh, Mr. Aso is there.
The Asho is there. Mr. TTD Endo is no more a counsel.
No more.
Mr. Kinta also is not.
They have special counsels, Your Lordship.
Mr. TTD Endo, is he still there?
No,
No longer.
Yes, resigned, Your Lordship.
The standing counsel
There's no standing counsel, there's only special counsels.
now.
Lordship. Being led by Aso, Lordship, senior advocate.
There must be panel.
They are lawyers, sir. They are panels.
Who can give us that information with regard to this? We do not need special counsel for that thing. Whether district council has any fund for tackling with those cases where indigent person is there. That is what the information we need. How can we solve it then? But it's not only the mere provision of law. We have to take into consideration the reality
The
of
circumstances.
Yes.
As well. I think Mrs.
We are
PS
not there in the panel district.
I'm not there, Lordship.
Mrs. P.S. Nongri is there as well.
There are two panelists, Lordship, Miss
Can you
P.S. Nongri and-
no? Can you of your own? No, you cannot.
It will be very difficult.
I do not know. It depends upon sometimes.
Yes.
And which way this thing? Shall we ask for appearance of any?
I think we can ask for appearance of some counsel from district councils representing district council.
This petitioner filed an application to allow her to file a suit as an indigent
person.
On that basis, court had ordered an inquiry. And then say that you bear the cost of it.
15,000. In fact, if I paid a 15,000, I could have actually paid for the stamp duty itself.
Can't it the lawyer can lend some help? Now, there is a provision of appointing a lawyer as inquiry officer or else by the
Chief
ministerial staff.
The first should be the ministerial staff, unless otherwise some
Okay, so
circumstances
here
then.
the court has directly appointed as a lawyer.
Lawyer, sir.
Probably realizing that there is no fund available for that.
Might be.
We have to handle the situation by taking into consideration the practical difficulties. Okay, heard Mr. Pasal, Learned Counsel, appearing for the petitioner.
Petitioner.
Stop. The grievance raised in the application is against an order dated, against the order dated 19/8/2025, passed by the judge, District Council Court, Shillong, in Miss Case number 90 of 2025, whereby the petitioner was asked to bear the travelling expenses of the inquiry officer who was appointed to inquire into the assertion of the petitioner to allow her to file a suit in the capacity of an indigent person. Is that all right?
Yes.
Step. Mr. Pasa, Learned Counsel for the petition, contends that such an order asking the petitioner to bear the travelling expenses of the inquiry officer defeats the very purpose of provision of law. Stop. He contends that the law allows the ministerial staff of the court concerned to be engaged for conducting inquiry into the claim of a person being indigent. Stop. Paragraph. Conducting an inquiry to determine whether a person is an indigent person or not would definitely require some expenditure, definitely incur some expenditure, as would definitely stop. Stop. It is not known at this stage whether District Council Court has any system to tackle with such kind of expenditure. It is therefore stop, Mr. Dilani. What is it? Any system to, yes, pronounce correctly, otherwise the problem. Tackle with with such kind of expenditure, not that. If I say something mistakenly read that, do not record the that. Apply your mind and just stop. The learned counsel for the petitioner is not in a position to inform the court about the said aspect. Stop. The paragraph. In the above circumstances. Now, Mr. Pasa, if there is no standing counsel, whom can we ask for to appear? Just in the you will do one thing. You serve a copy of this order to the.
I'll serve the copy.
Yes. In the above situation, it would be advisable to seek assistance of the learned counsel representing the Khasi Hills Autonomous District Council. Stop. The petitioner shall serve a copy of this order. To the appropriate authority of the district council, so that service of the council, service of standing council, stroke any other council representing the district council can be availed by this court on the above issue on the next date fixed. That is all right?
That's all.
That will
That will suffice.
Okay. Stop. List this matter after 2 weeks.
2 weeks.
Oh, you may cite it that what you said in the last part, that learned counsel for the petitioner shall just serve a copy of this note to the appropriate authority of the district council, so that service of a standing council stroke or any other council representing the district council can be availed by this court to seek clarification on the issue raised in this order. Stop. Let a copy of order be supplied to Mr. So-and-so free of cost. Mr. Pasa, learned counsel for the petitioner, free of cost. Stop. List after 2 weeks.
Obliged.
Otherwise, again, you will have to spend from your money, isn't it?
Obliged.
Item number 20.
Yes. Ready? What is the matter?
This is a remission petition, my lord, where my representation was rejected illegally, my lord, in fact.
Remission?
My lord. May I start?
Yes. Yes, madam, ready?
My lord, I'm being led by Mr. Shulai, my lord. Otherwise, if my friend wants to begin, my lord, I have no
So,
objection.
the issue doesn't appear to be very long here. It will be a very short issue. It is non-consideration of prayer for remission.
My lord. My lord, because, my lord, what my limited submission as of now, my lord, is that the petitioner's prayer, my lord, is regarding disposal of his representation for remission.
That was done.
So, my lord, now we have done. So, my lord, either he has to challenge the.
Okay.
Yes, my lord, he has to
that has been
either.
done. And
Yes,
that,
my lord, we
that
have
order
filed an
has not been
affidavit.
challenged here.
No, my lord.
I have challenged this, my lord.
No, my
My
lord. we
prayer
have-
is for reconsideration of the representation which was rejected illegally, my lord.
So we have rejected, my lord.
No,
So
no.
they,
If you just a minute. Your application was considered and it was rejected.
Yes.
my lord, his representation is 2024.
Yes.
And our disposal is 2025.
Okay.
So, my lord, we have
But
subsequent.
that rejection order is under challenge in this.
No, my lord.
I have challenged.
My lord, may see have the prayer, my lord. My Lord, may I kindly have the prayer page number 11 to 14, my Lord, 13 to 14. My Lord, prayer number C, my Lord.
Okay.
The
There is
representation.
consideration of representation only.
And we have rejected, my Lord.
Then see your prayer, page 14.
While reconsidering the representation letter dated,
What is the question of reconsideration? Please direct the respondent to what happened. Respondent so and so shall be not be the parties. Be pleased to direct the respondent to release the petitioner by remitting the sentence of his while reconsidering the representation dated.
yes.
And we have, my Lord, taken a
Can
call.
the High Court can a High Court pass?
Yes, my Lord.
Wait. You want a direction should be passed, directing the authority concerned to reconsider your petition and to remit. Now, if High Court says that the sentence should be remitted, then what would remain for them to reconsider? Can a direction be issued? Mandate must be issued while directing a particular authority to dispose of a representation.
My Lord, similar matter, Namam Thai, if my Lord, can you come to the affidavit
Yes.
filed by them? This affidavit is based on two things. Page number 4 of the affidavit, my Lord.
No, but then see, here is the rejection order. Until unless rejection order is set aside, what is the question
Yes,
of
my lord.
reconsideration? Can a matter be reconsidered until unless there is a law that even if courts remand something for reconsideration, impugn order has to be set aside. Otherwise, that order will stand.
I'm not suggesting, my Lord, but the case which my friend is referring, the remission given to that incumbent was not by the direction of this honorable court. my lord.
Where is your statement here in your writ petition that your petition was rejected?
Yes, my Lord. This is Annexure 6, page number 33, my Lord.
No, your writ petition, which paragraph you have stated that is rejected in the writ petition? Okay. Paragraph 8.
Yes.
My lord.
Now, this rejection order is not under challenge here.
Yes, my lord.
You have not asked for setting aside of that.
And he is aware of the rejection.
Now, without setting aside that, how can this matter be reconsidered?
My Lord, kindly come to para 9, my Lord.
Yes.
That the petitioner begs to submit that the notification number such and such dated 31st January 2025 was passed after 1 year from the date of submission of the representation. Hence, the notification is not applicable in the case of the petitioner, since the representation of the petitioner is dating 31st January 2024, and the said notification came into effect only when the said notification was published in the Gazette notification of Meghalaya on 20th February 2025, and as such, the impugned letter dated 19/6/2025 is liable to be set aside and quashed, my Lord.
What is that in the prayer? And where is the impugned letter dated? Here is a question of where is that prayer? Is that your thing? In your prayer? Where is that?
Even para 10 also I have.
No, but then where is that in the prayer? Prayer should be in prayer, isn't it?
My lord, may
It's a
kindly.
problem, you know.
Kindly have page 33, my
These
lord.
are the kind of, but then, madam, this to adopt a very technical approach in this kind of petition also becomes very difficult.
Yes, my lord.
Yes,
I won't
for the
deny
more
that.
than
However,
80
my lord,
years.
this is a case of double
It is
murder,
not
my
an
lord.
excuse for the lawyers not preparing the petition as per the requirement of law. But then to reject something on that, that also becomes very difficult.
We have
Especially this kind of legislation.
We have given them the accused, my lord, the convict, a liberty to challenge the order, my lord. So he could have challenged, my lord. Rather than
Before whom?
my lord, page 33, my lord, that
No,
is
before they can challenge.
my lord, they can challenge either before the competent authority or my lord before
Who is the competent authority?
My lord, that will be.
Oh, should not be assumption. Please, if you say
My
there
lord,
is a
yes,
law,
I
then
have-
please,
I have to
please tell us. Then we will
verify
direct
that.
them to there. If there is an authority for reconsideration, definitely.
I have to verify that. My lord,
My paragraph 8, 9, 10, all are my prayer is there, my lord, to set
The
aside any
petition,
question.
body of the petition is not prayer, mister.
My lord.
Why you are trying to do something which is not supported by your own petition?
My lord.
You have omitted to make it, admit it as a mistake.
My lord.
That will be better.
My lord.
Instead of trying to justify something wrong, why? See, yes, madam, just tell us where is that? Where is the order? Where is the order? Is
My order
annexed
is at
6?
page
You see, annexed 6, isn't it? Mr. Day, annexed 6.
Yes.
Page.
33, my lord.
And where do you say that you have given
My
the
lord,
opportunity
the
to challenge?
second paragraph says the convict reserved the
At
right
what
to
page?
challenge
What page?
before the court of law, my lord. Page 33, Annexure 6, my lord,
affidavit-
of the writ
affidavit
petition.
Page 33.
Yes, my lord.
So, my lord, they have not challenged this order, my lord, in my humble submission, my lord. They have only come for reconsideration of the representation.
Yeah, the appropriate court of law.
My lord.
Then?
Yes.
There's before appropriate court
Yes,
of law.
my
Yes,
lord.
my lord.
And my lord, if it's about reconsideration, they have to wait for another 1 year, my lord.
My lord.
No question. See, if you say that if you have a policy which says the person who is involved in twin murder, they will not be considered, then give us, show us that punishment. We'll just say. Where is that? He has been involved in two this thing.
My lord,
Murder of
yes.
two or more
It's a
persons.
case of double murder, my lord. He's convicted of double murder, my lord.
Double murder.
My lord.
So that is a twin murder.
Yes, my
Twin,
lord.
my lord.
And if there is a policy, then
My lord.
You have to
can
challenge the policy.
can you consider something which is not otherwise sanctioned by the policy?
My lord, what happens when there is no policy? The guidelines which has to be followed is the NASCA versus Union of India and others. These are the principles which has to be followed, and read with section 432 and 433A of the CRPC, my lord.
No, where just show us a law that the ground mentioned in page 35 that a person involved in two or more murders will not be considered for remission. Now that is not a correct proposition of law. Just give us something on that. Make it shortcut. You do not have to go here.
In fact, my lord, I will not come under that policy.
You have not seen the policy of the government.
I've seen, my lord. 2025, in fact, 2026 also another policy which came.
Yes. So 31/1/2025, you say that
in
there
fact-
is no such, nothing there.
In fact, I would like to submit one judgment, my lord, where it says that
Before you
the
come to the judgment, let us just first see the policy. Why to go to judgment? If you say it is not there in the policy, then we will hold this order to interfere with
2025 policy that is there, my lord.
31/1/2025, where is the policy? You have all that policy?
Page 25, my lord.
25, my lord.
Annexure 5 of the writ petition.
Show us that provision where it is stated, madam, that a person involved in two or more murders will not be considered.
My lord, kindly come to page 27, my lord.
CA.
That is the heading is eligibility of convicts, my lord. C, my lord. This is the category under which they shall not be eligible for grant of remission, my lord. Page 27.
CA, isn't
Yes,
it?
my lord.
CA, my lord.
Yes. So it is there. You cannot say it is not there, they're not provided in the policy.
Yes, it is there, my lord. But the thing is that, my lord, if my lord come to page number 26 of the petition, where it says, therefore the governor of Meghalaya is pleased to notify the remission policy 2025, which shall come into force from the date of its publication in the Gazette of Meghalaya.
Yes.
Now the publication of Gazette, this Gazette was published, it will be in the Gazette, this Gazette was published on 20th February 2025, my lord. So any law or
23 February
20 February, my
20
my lord. February 2025, my lord.
2025, yes.
So this will be implemented from this date, my lord, not prior to that, my lord.
Now when this order was passed?
19 June, my lord, 2025.
So after this order?
Prospectively, my lord.
After the remission, see, to contend that your remission application was filed on a day when this policy was not in force.
My lord.
And to say that the day on which the policy was taken up on consideration,
my lord,
and the policy was not in operation will be two different things, isn't it?
My lord.
Now, that means so far as your case is concerned,
yes,
the policy was holding the field on the day when it was taken up for consideration.
my lord.
But then on the day on which you applied it,
it was not there.
Okay. Now, to say that, so it means your case is that the policy could not have been applied in the case.
My lord.
Now, show where is the flaw?
So, my
Just
lord.
show that. See,
yes,
you cannot say that this proposition minus policy cannot be applied.
My lord, any policy.
We may go by your submission.
Yes.
We may say
yes
that just have a query may be a bit long.
My lord.
We may say that yes, you are correct in contending that policy was not in force on the day on which you applied for remission.
My lord.
But then the proposition made in the policy will not be applicable minus there being a recognized policy. On what basis you can say it? Still, it may be a ground for consideration.
My lord.
Rejection.
Any law or any policy which comes subsequently, which comes, it cannot have a retrospective effect, my lord.
That is known. We are not saying that. The question is not that.
This will violate Article 20, Clause 1.
It is not at all that. You are trying to say that the policy cannot be applied. Yes, there cannot be two views on that. It cannot have retrospective effect.
My lord.
Until and unless that has been specifically.
In fact, if it is for my beneficial, then it can be.
So far as the criminal legislation is concerned.
My lord. My lord.
The law, so far amendment or change or coming of new policies come, the normal thing is that it will not have a retrospective effect, except in criminal and service legislation where it has been given for the benefit of the employee or the.
Yes.
That is the proposition of law. So you do not have to basically come and show it before this court. Okay, this is all right. Now the court query is that minus the policy, even that your involvement in two murder cases, if it is taken up for consideration and rejected on the ground, then what is wrong in it? Minus the policy. Forget about policy.
Yes.
The review committee says and it says no. He is involved in two, he should not be. What is wrong in it?
In fact, my lord, come to the opinion given by the session judge,
Okay.
which is in the.
Any chance of Mr. Shulai coming here, madam?
My lord, it's quite difficult, the matter. Mr. Paul is there, my lord. So
there will be matter will be lingered wherever
it
he
appears, my lord, it appears.
If I may just read the
However, my
opinion
lord,
of the
to my
judge, my
humble
lord.
submission, he has to challenge
You may,
the order,
but
my
we do
lord.
not know whether it will dispose of because if you raise something, Mr. Shulai will be needed.
Yes,
He
my
will
lord.
not be able to reply to respond to your all thing. Anyway, just show us, yes.
Yes. This is the opinion given by the session judge, my lord. It's page number 10 of their affidavit, my lord.
Achha, just before you come, sorry. Now you say that your application was made on a day when no policy was in existence.
My lord.
Any law on that? That this has to be considered by taking into consideration the date on which it was filed and not the date on which it is taken up for consideration.
This will be covered by one judgment, my lord. This is State of Haryana versus Jagdish, my lord,
What does
where
it
it
say?
says that the date of policy when the policy was there, particular policy was there on the date of the judgment, that policy will be applicable, not the subsequent one, my lord. This is the judgment which.
Date of the judgment.
Date of that judgment.
Date of judgment means like that is the order here.
There was one existing.
Is it? It means is it the date of the order?
No, when the judgment was passed, already there
What
was.
is law promulgated in the decision which you are seeking to refer.
Yes.
What did it say? That
The policy was already there when the judgment was passed.
judgment means which judgment?
When this particular.
By saying judgment, what do you mean?
If I may read, my lord, from the.
Anyway, you can read it. You can read it, but then you just say, if you say,
No.
you're talking about the date.
Date.
Isn't it?
Yes.
Now, what should be taken into consideration? Is it the date of the application, or is it the date on which the committee set it for consideration? That is what the court is.
No, it is the judgment, my lord. It is when the judgment was passed, that particular time.
The judgment, by saying judgment, what do you mean? Judgment by whom?
Judgment of the session judge, my lord. When the judgment was passed, that time there was no policy. When the application was also filed, the representation was filed.
Wait. Session judge judgment in what case? In the cases in which the person should convicted.
Yes, my lord. That time there was no policy.
The law. I do not know.
They have the scope for
Date
appeal,
of
my lord.
conviction is 10 years
Yes,
back,
my lord.
20 years back.
Because we are post-conviction, my lord, this remission policy.
what-
Yes.
Very- it seems
So when I filed representation also, that time also there was no policy, my lord. So now.
That is why, Mr. Adre,
Yes.
make it simpler. Do not make it complicated. Why you are trying to make it complicated? If you say the date of judgment, this court is asking you, by saying date of judgment, you mean the date of which judgment?
Date of when he was convicted, my lord.
The impugned judgment, my lord, of conviction. The
Impugned
impugned
judgment
judgment.
of the conviction.
Yes, that is what my friend is referring.
Yes.
So it means you want to say the remission, the prayer of remission has to be taken into consideration.
My lord.
Taking into consideration the date of judgment by which he was convicted.
What I'm saying is that, my lord, as per this particular judgment, it says that the date of judgment, this particular policy was there. But in my case, it is completely different, my lord. When this judgment was passed, or when the representation was also filed for remission, that time there was no policy, my lord.
That is okay, we understood that. There is no dispute with regard to what you are trying to communicate. You see, we got it. What this court is asking you, to say that the policy will not have application in this case, what date should be taken into consideration? Whether it is the date of your application or the date of consideration. Now, if it is the date of consideration, admittedly the policy was in existence. Now, if you want to say that it should be on the date of the application, then please give us some law on that.
When, if we go by the representation, my lord, when the representation was filed, it was 31st January 2024, my lord.
Yes.
That point of time, there was no policy.
Exactly.
Yes.
But see, so that is what. But then the fact remains that when this, on 1906, when this order was passed, impugned order was passed, policy was in force.
Yes.
Isn't it?
Yes.
So please try to understand the court's order. I think kindly, please, I do not know whether the court has not been able to communicate to you or not. Whether the date of application should be taken into consideration. Date of application is the date on which you filed the application. for remission.
Representation.
Or the date on which they set it for considering it should be taken into consideration for application of.
It is the date on which I have filed my representation for
Exactly,
remission, my
that is
lord.
So now on what basis you say it? Just that is what you just was. Please.
So at that time, when I filed my representation, my lord, at that time there was no policy at all.
Yes, you said it, and there is no dispute about it.
There is no policy. So when there is no policy, so it has to be governed by or the guidelines which has to be followed is Lakshman Naskar versus Union of India and others. And the
First, before you come to the merits of the thing,
my lord,
just tell us where it is provided the date of application should be taken into consideration.
My lord.
You said that no date of consideration by the respondents cannot be taken into consideration.
Yes, my lord.
Okay, for deciding the date of application of the policy, It is a date of application.
No,
Now,
no.
where is that provision provided?
There is
We have understood your submission that policy will not have any application if date of your application is taken into consideration and the decision of such and such will hold in place.
Yes, madam.
Isn't it?
Yes, madam. Yes.
But then first just satisfy the court that the date of application will be taken up for consideration whether a policy will apply or not apply.
My lord, my basic understanding of law, my lord, it is when I have filed a representation, that was much before the policy.
So you do not have any law.
No, my lord.
You do not have any law.
No,
Now,
it
was the
is
decision you
governed
were
by
trying to-
this judgment
what,
and-
what is the decision which you are trying to place before the court saying?
That is the guideline set by the Honorable Supreme Court, my lord.
No, but then the date of judgment means what? What for date of judgment is required to be seen there?
My lord,
We are on simple question, Mr. Day. I do not-
2008, this impugned judgment, by that judgment I was convicted, my lord. That was in 2008, my lord. At that point of time also there was no policy. When after 15 years I filed my representation, that time also there was no policy, my lord.
Yes, we got it.
And when the policy was passed in 2025, that is exactly after 1 year. That time also, my lord, it cannot be applicable because when, my lord, the
Your submission is based upon certain law, isn't it?
my lord,
You must have, while you are making submission, you must have formed your opinion on the basis of some law, isn't it?
yes, it is the.
Now, if you is there any clear law which says that the date of application should be taken into consideration for deciding whether the policy will be applicable? Otherwise, we will decide it. We know which way to tackle it.
Yes, similar matter
But
came
whether-
before your
whether
lordship also.
there is a law. No. You may be correct in contending. Yes, the date of application should be taken up for consideration. Okay, but then the court question is that whether there is a clear law on that or not. Do you have anything? Or if you do not have, you can probably, if not specific to this, maybe in relation to some other thing you may find it. Now, if you do that thing, that things will become simpler here. If you make out a case that yes, the policy could not have been applied here, then things become easier for you because their rejection is only because of that terms in the policy,
Yes, ma'am.
which was not at all applicable in your case. So there has to be an independent consideration by following the proposition of law
Yes.
as laid down in that. That is what your case is.
Yes, my lord.
So give us some law so that it helps us in finding the date.
When there is no policy, it is the general principles with which the.
But see, policy was there on the day on which it was considered, taken up for consideration.
Yes, my lord.
Here it is the case.
Yes, but
Now,
when I
your
filed,
contention is the date of application should be seen.
my lord.
That is probably your correct, but then there is some law to back it, isn't it? There must be some law.
It is when in the absence of any policy, my lord, it is the general principles of.
You are again
master
going to
and-
policy.
And
we are on the date, and you are going to policy.
it is after 14 years of from the date of the application was filed after more than 14 years, in fact, and the eligibility it says as per the
Your
section
conviction was for how many years? Life
life imprisonment, my
So
lord.
after 14 years, you become eligible for remission.
Yes, my lord.
Now
That is as per
Now,
the.
you see, your prime contention is that the date of application should be taken into consideration.
My lord.
Now, can you back it with a law, proposition of law, where you say it?
It is as per the
Their
section.
contention is that Ms. Kalni contended that no, the policy was in force when the matter was taken up for consideration. Admittedly, yes, because it was done recently in 1906, isn't it? After
Yes.
the policy came into force.
But any law
Okay.
which comes which cannot have a retrospective effect, my lord.
Yes, so there show us that law where see retrospective effect means what?
My lord, in
See,
fact,
question whether it will have a retrospective effect or not It is dependent upon the determination of the date.
In fact, from the policy itself, 2025 policy itself, it says that it will be implemented from such and such date, my lord. Not prior to that. My application is prior to the policy, my
That's
lord.
okay. They have applied it because they have taken up your application thereafter.
But that cannot be, my lord. I have filed my
Show us
representation.
the some law. If you say that cannot be, that show us some law. You say that your date of application which is material here.
My lord.
Say that. Any law you have. Yes, Mr. Shulai, what
This will violate Article 20, Clause 1, my lord, if that is.
again you are going to somewhere else, we do not know.
Ahmed,
Simple thing is just simple thing, give us a law saying that that is the day of your application which should be material. Show us that.
Ahmed, please, Your Lordship. Lordship, in my humble and respectful submission, Your Lordship, this repetition is defective, Your Lordship. Lordship, kindly have a
Yes,
peaceful
that has been pointed out in his colony. The rejection order, not an
Lordship,
challenge
yes.
order.
That is
It's
not-
okay, we can understand, but then this kind of petition, maybe we may not adopt that much technicality because this order has been incorporated and there are certain amendments in the writ petition assailing you that action. Okay.
But it has
Now,
to
that
be.
is okay, Mr. Sulai, we are just on one thing. Of course, though there may not be some dispute, but then we want Mr. Day to place it before us. The date.
Now, then another aspect of the matter is that, Your Lordship, there is a policy in place.
Yes.
And that policy says that a person who has been convicted for the murder of of two or more persons, Your Lordship, will not be entitled
Yes,
to.
we have dealt with that
Lordship.
also right now. You were not
Whether
there.
my-
Colony was there. So we have come across. See, we have come across. Now what happens? Your policy came in the year 2025.
Lordship, yes.
It made applicable from February 2025. Okay. Now his application was taken up sometimes in June 2025, and by applying the provision of the policy, it was rejected.
Lordship, yes.
Now Mr. Day has taken a plea here that no, his application was filed much before the policy came into existence. Okay, so you should have taken into consideration the law, applicability of law as on the day of the application and not the provision of the policy.
Lordship, kindly see, Lordship, the remission policy has been adopted by the state in view of the order of the Supreme Court, Lordship.
All right, that is all right. There is no problem. But even then, the application cannot be
At that particular time, Your Lordship, there was no policy in place.
All right.
There was no policy in place.
All right, but then he said that there are some certain judgment which was
Let him
holding the place.
let him certify that, Your Lordship.
Now, only thing is that basically before we come to all other contention of Mr. J concerning merits, what we wanted him to place some law that it is the day of his application which should be taken up for considering whether the policy will be applicable or not. But that is what. We are stuck on that. Now, if you do not dispute that, then let him proceed. We will take it as that way. They will say,
If that is his argument, Your Lordship, then let him. Because our case is that.
Are you disputing the fact that it should be decided by taking into consideration
Lordship,
the date?
because there was an application in the year 2024.
Yes.
Then subsequently, Your Lordship, pending that application was pending, and subsequently the policy came into effect, Your Lordship, and we, the state, took a decision on the basis of that policy, Your Lordship.
That is okay. So now what should be the effective date?
So the effective date, Lordship, that policy only. That means
that is what
the
you are
case
saying.
of the writ petition has to be determined on the basis of the policy, Your
By
Lordship.
applying the policy.
Yes, Your Lordship.
Because your contention will be that before that there was no
policy in place.
no regulation so far as the
Lordship,
consideration
yes.
is concerned. Now the policy will regulate it.
Yes.
That is all right. But then he says that no. He says no, there is a decision which should hold the fate. Okay. This
So if that be the argument, there must be a
Now,
should
pre-policy-
support with a certain authority, Your Lordship.
So that is why his contention is that the pre-policy law will apply. And he says that is regulated by some decision which he knows, okay.
If my friend can share that,
So
Lordship will.
to say that whether the policy will applicable or the decision which he says, the date becomes very relevant factor, date of the application. Isn't it?
Lordship,
Now,
yes.
whether the application, consideration application should be taken into consideration by. See, Mr. Day, one thing Mr. Shulai is very correct. The policy is basically to regulate a situation which was unregulated so long. Okay. Now this policy also has come pursuant to certain direction of the apex court. Okay. Now if your application is taken up for consideration post policy, then definitely it is a policy which will regulate. Why the date of application? If you contend that, you have to give us a clear law. It is only by contending that violation of this right, that right, you have to first convince us. You must be convinced, should convince us so far as the application of date is concerned.
And Lordship, then that decision of the Supreme Court also has been taken cognizance by the division bench, Your Lordship, where certain direction had been issued to the state, Your Lordship. Where are those? Yeah, Sumoto.
That decision of the state means like which decision?
Lordship, there is a Lordship, this is in WPC criminal number 12 of 2025. This is the order of dated 3 February 26, Your Lordship. It said that the learned Advocate General placed on record the remission policy of 26 framed by the government of Meghalaya, that is the notification dated 2nd January 26 on the last date on so and so. Needless to state that having regard to the remission policy of 26, the Secretary SLSA shall identify the cases where the accused would be entitled to remission and premature release based on the remission policy of 2026 and file necessary application before the bench having jurisdiction so that the convicts accused person can avail of the benefit of the new remission policy. We also direct the superintendent of jail to identify the accused person convicts who would be entitled to premature release remission as per the remission policy of 2026 and to take appropriate step in that regard at the earliest. So, Your Lordship, even the division bench also of this honorable court also recognize the fact, Your Lordship, that the remission has to be done in terms of the 2026 policy, Your Lordship.
That is where, Mr. Dane, that's the normal law about the retrospective.
But if my friend still wants to pursue with that argument, Your Lordship, my friend will share us.
No, he will, if he pursues also, he will have to give some law.
Lordship, yes.
See, because submission on question of law has to be supported by something.
By an authority, Your Lordship.
See,
Yes.
and of course, if there is no authority, then definitely you have to determine it by taking into consideration. Now, Mr. Day, so far as the population settled proposition of law, that there should not be a retrospective application of law, except for the service law and criminal beneficial legislation. This may not apply strictly apply in place of a policy here. That is one aspect, just keep it in mind. Because the policy has been formulated to regulate regulate an area which was totally unregulated so long. So whether the same proposition will apply here or not, that is the main thing. You just conduct this thing, find out trumping so far as the application of date is concerned.
Yes.
Had there been any other policy in existence, maybe your submission would have been. But then it appears that even if you take into consideration the date of your application, there is no policy in operation.
Yes.
You may say that yes, there was a decision, but then the fact remains the day on which your application was considered, there was a policy. So what is wrong in it? That way there means come back. When you come back?
After 2 weeks,
Please. These are technical issues of law.
Yes.
Instead of hitting around the bush, come to the point.
In fact, this
make a
is the
research on
judgment
that.
which I was relying, my lord. Here, exactly the same thing happened at the time of the judgment. The existing policy which was there,
Yes.
that has to be considered, not which came subsequently, my lord. But in my case, it is also kind of similar, my lord.
What is the
In my
decision?
case,
Yes. What is the decision you are trying to This has not been reported anywhere.
Reportable.
Why don't you come for proper this thing?
taken out from the Supreme Court website, my lord.
That is all right, but then there is no concurrent this thing. Journal, citation of a journal. That becomes, things become easier. Anyway, where is that? Which paragraph you want to?
para 5, 6, and the last para will be 42.
Para 5, 6.
And para 42, my lord.
Your Lordship, in this case, Your Lordship, kindly have internal paragraph 5, Your Lordship. There was a policy, Your Lordship.
Yes, that's what
page
I'm
3,
saying.
Your Lordship.
Yes, there was. That's what I'm saying. There was a.
There was a policy.
In your case, there is no policy.
But in the present case, Your Lordship, before Your Lordship,
What
there
happened,
was no
my lord?
policy.
In this case, what happened? Subsequent policy came. So, can you just come to para 42, my lord?
Just a minute, let us see para 5 first.
Can you come to internal page 3, Your Lordship, paragraph 5?
Yes.
Lordship, kindly see, Your Lordship. If I may read somewhere in the middle, Your Lordship.
Yes.
The respondent, Lordship is with me.
Yes.
Having served more than 10 years imprisonment, approached the High Court that in spite of having undergone the sentence as per the aforesaid policy dated 4/2/1993.
Okay.
So in this case, Your Lordship, there was a policy, but not in the present case, which is before Your Lordship. His case for premature release was not being considered in view of the new policy of short sentencing introduced on 2008. The policy dated so has been brought on record, which recite that the same was being issued in exercise of the power conferred under so and so. The same for, for the recite that in supersession of the government memorandum dated so and so and all other earlier. Then Lordship, kindly come to para 42.
Just a minute.
Lordship, the last sentence is the power exercised under Article 1.
The consideration of remission, is it automatic or the person concerned has to apply?
No, the prison department.
Lordship, the as per the policy, Your Lordship, there should be an application.
It is not that the state should do it automatically.
Lordship, that is also a
Now, whether a
debatable.
responsibility cast on the state, say supposing if a person is not considered, he doesn't file application and he is not considered after he fulfills the qualifying period of detention, can state be blamed, saying that why you have not considered?
It cannot be, Your Lordship.
No. See what the.
If I may read 42, para 42, my lord.
Yes.
Yeah. We have already noticed that the earlier policies, including the policy dated 4/2/1993, refers to the exercise of powers under Article 161 of the Constitution, whereas the policy dated 13/8/2008 is in exercise of the powers under Section 432, read with Section 433 and 433A of CRPC. The restriction under Section 433A is only to the extent of the powers to be exercised in respect of offences as referred to under Section 432 CRPC. The notification dated 13/8/2008 is therefore under a rule of procedure which is subordinate to the Constitution. The power exercised under Article 161 of the Constitution is obviously a mandate of the Constitution, and therefore the policy dated 13/8/2008 cannot override the policy dated 4/2/1993. My lord.
Situation is totally different.
Here it is
The
subsequent policy came.
First policy had a reference of Article 161.
Yes.
And the second one
is a
of the provision of CRPC Section 432. In that context, this thing has come, this observation has come. Your case has nothing to do with this.
In my case, my lord, there was no policy.
That is why.
Yes.
So that is, we are totally in a different area. We are in a different area. So there you need to show us that the date of, first of all, it is the date of your application which should be taken into consideration for deciding which policy will apply. Okay.
My lord.
That is one thing. And what else was there? The second the point the court has forgotten. No?
My lord.
There was something else this court was asking you before.
Which law will be applicable?
Now, say supposing, even let us, if we assuming that the policy was not applicable in your case, but then the deciding authority takes into consideration that yes, indeed you were involved in 2 murders, and on that basis rejected. How come that be prima facie be considered as illegal?
My lord, my lord, if that's all about merit, my lord. In the judgment itself, it is written that in one of the paragraph it says that he is the needle of suspicion goes to such and such person. Hereby I convict such and such person, and based on this he was convicted. So to say, he was convicted
Now,
based on
if
suspicion.
your conviction is on the basis of
Suspicion.
suspicion, you have not challenged that conviction.
This is
That
not
would
a
have
criminal
been,
label. That's
that-
why, my lord.
That have been even one ground, this would have been interfered with, if that is the thing.
My lord.
Suspicion cannot be a ground for conviction in a criminal law.
This is not a criminal appeal. That's why I have not challenged all this.
You
thing.
cannot raise it here.
That's what I am. I'm not raising all that.
But then you have undergone detention on the basis of very order which you now you say illegal. At least bring something on the date.
And the opinion of the judge, my lord, is also very clear, which was cited the law which was the guidelines which has to be followed under given by Lakshman Naskar versus Union of India and others, and his position at this at the time of the passing this judicial opinion.
This Lakshman Naskar case, you say that if there is no policy, then the proposition laid down in their judgment has to be followed.
Yeah, read with section 432 and 33. my lord.
Now that is okay. 432, see 432, 33, basically.
432 is I'm
lay
eligible.
down what are the situation.
Yes.
Okay, when should be accepted and when should be rejected.
More than 14 years and all these things.
Now, if you say that, does it say that this proposition will follow even if your application is taken up on a day when there is a policy on existence?
No, my lord.
That is what the problem is. If it is no, then you have no case. You please do some research on that.
My lord.
See, three things. Admittedly, the day on which you applied, there was no policy in force. But later on, when your policy was taken up for consideration, there was a policy. Okay. Now, if you want to say that the date of application, that is what is to be taken up, then what has to be taken into consideration, then you have to give us some law on that. At least some indication. You may not have deceit event kind of thing. Okay. And now what else? Many things comes and it goes. We do not know. Anyway, just first you forward, just satisfy the court on that, because this is what your argument is based on the date.
My lord.
See, you can all other defenses, all other grounds become applicable once you say this is application. Now, second about this application of that case which you referred to. What is that? The second one. Second is
Lakshman Naskar.
Yes, Naskar case. Lakshman Naskar case. Now, whether this judgment will still be applicable when admittedly on the day of consideration there is a policy. To say that policy will not have any retrospective effect, you have to go first. Policy will definitely not have any retrospective effect so long there was another policy holding the force. Okay, holding the arena. But then, admittedly, your case you say there was no policy. So, in such a case, retrospective application may not be specifically barred. See on that thing, that line. Third, Land Council appearing for the parties. On pre-argument by Mr. Day, Land Council appearing for the petitioner. To Land Council for the petitioner to prepare further. This is matter after 2 weeks. Please see on these things. See, these are the foundation, backbone of your case. You should be hitting hard on those.
Yes.
Instead of going to all other things,
Yes.
Article 20 and all those things. You can see it later. But then once you establish it, because their orders is nothing. They say in view of the policy, such and such, rejected.
In fact,
Now, if you can make us show us this policy was not all application, you interfere, you send it back again for reconsideration.
My lord. In fact, similar matter came before your lordship.
Yes.
Jatil Borough versus State of Meghalaya.
Okay.
That was decided. In that case also, the state have allowed his remission.
No, was it, there is a order by this court
My lord,
to reconsideration, on what ground?
that reconsider part is Nabam type. That is also, it was, this judgment is also from Meghalaya High Court, my lord. And this Jatil Borough is, my lord, it was your order, my lord.
Anyway, we'll see it later on the next day. Please, just let us, now you know very, very well where your case stands. So just prepare on that.
My lord.
Nothing more. Yeah.